violation to be assessed against somebody for disturbing the entire line than they would for disturbing one trap. So if you're going to make a change on the latter one, you may want to also look at making a change on the one regarding disturbing the trap.
Commissioner Moray.
Thank you, Mr. Chairman. A question that I have for you guys is on the removal of demerit points. What's the time frame that, or is there a time frame that these demerits go away, or is there a mechanism to reduce the demerits, and what that mechanism is?
Well, the demerits do fall off the record after 60 months. So after 60 months of conviction, that violation will fall off. And if there's 3 convictions, just say the other 2 will remain until that 60-month period for the next one comes up. And then there is a mechanism to remove points is once you hit 9 points, once you receive 9 points, you can take a hunter education class once every 60 months to reduce that by 4 demerit points. So one class within every 60-month period.
Okay, any other questions? All right. Commissioner Macbeth.
We got a lot of correspondence that, well, let's put it this way, I felt was inaccurate. And I just would like to clarify how the department is going to look at the issue of the trespass issue, because we had a lot of correspondence that basically where sportsmen were worried that the mere act of trespass, being on somebody's private property, would trigger this demerit point situation. And we had discussion on this in the meeting in Tonopah, and I came away after reading in our NRS very convinced that the violation that we were talking about was a very willful violation, and a violation that that I personally considered a very despicable act. And so I'd like to go with that and just clarify that for the record. We're talking about a violation of 503-240, and we'll just read it. It says it is unlawful for any person to hunt fish in navigable waters or trap upon land which is private property, where the person has been warned by the owner or occupant of the property not to trespass in the manner prescribed in NRS 207-200, or where signs are deployed forbidding hunting, trapping, and fishing without permission obtained from the owner or occupant of the private property. Any person using the private property for hunting, fishing, or trapping shall comply with the provisions of NRS 207-220. So the private landowner has an obligation to post their property in accordance with NRS 207-220. So now when we go to NRS 207-200, thanks. It basically is covered in 1B. Willfully goes willfully. That's intentionally. Legal term, but it means that you have the law enforcement has to prove willfulness, which is a very, very tough standard. It's the highest. Willfully goes or remains upon any land or in any building having been warned by the owner or occupant thereof not to trespass, is guilty of a misdemeanor. And then in 2, a sufficient warning against trespassing within the meaning of this section is given by any of the following methods. A, if the land is used for agricultural purposes or for herding and grazing livestock by painting with fluorescent orange paint not less than 50 square inches of the exterior portion of a structure or natural object, or the top 12 inches of the exterior portion of a post, whether made of wood, metal, or other material, at intervals of such a distance as is necessary to ensure that at least one such structure, natural object, or post would be within the direct line of sight of a person standing next to another such structure, natural object, or post, but at intervals of not more than 1,000 feet in each corner of the land upon which upon or near the boundary, and each side of all gates, cattle guards, and openings that are designed to allow human ingress into the area. And it goes on. To me, it sounds like law enforcement has a pretty tough case, and it's going to require a landowner to have complied with this very specific statute, and then on top of that, willfulness, and maybe even a warning, right? Is that how I'm reading it?
You're exactly right, and I wasn't here for the discussion at the Tonopah meeting, obviously, but you're exactly right. And to be clear, as a department or a division, we don't have an opinion one way or the other. We'll continue to enforce it the same, whether it's 3 demerits or 9 or 12. But you're exactly right. I read through all the correspondence that came in from the public and the game boards and everything, and it was a little bit misled because, like you said, to borrow one quote, it said, poor schmucks innocently traipsing across a checkerboard of unposted and often unfenced private and public land. That's really not the case. Obviously a lot of the correspondents never read the NRS. And you're right, the NRS says, where the person has been warned by the owner or it's been posted, in the manner prescribed in 207-200. So I can tell you that specifically from my own background, last year I probably handled 7 or 8 of these calls in Humboldt County. Seems to be a worse problem every year in Paradise Valley or Arvada, some of the ag lands around Winnemucca. But out of all those calls that I went to last year, I issued 1 citation for it because the vast majority of the time I get out there, and it may be very clear to you and me that it's private land. 2 years ago, I had a dead deer laying literally on a fresh cut windrow of alfalfa, but there were no signs on the fence, and so I was not able to pursue that with prosecution or citation or anything. So. Yeah, if the land is signed, adequately as described in 207-200, marked with, post paint, all that sort of stuff, then we would, be looking at a citation. But the vast majority of the time, landowner calls up, says, "Hey, there's a guy in my field right now." I go racing out there, and he says, "Yeah, there used to be a sign on that post," and that sort of stuff. So I've been trying to get them to paint posts and sign better, because when I show up and I'm unable to give the guy a citation, the landowner gets frustrated that we're not taking any action in it. But obviously the burden of proof is ours to show that they were willfully intending to be on that private land after being warned not to.
I'm sorry, but I think there's been an update. If the land is using, it's 207-200-2-A, if the land is used for agriculture purpose or the herding or grazing of livestock, they can paint, if it's in active agriculture. I thought there was the way that you could go after the windrow situation, as you just explained. I thought there's been some updates that would help you clarify that.
The update that I think you're talking of actually took us back the other way. It used to say, well, it still says it, that fencing is a means of posting it, basically. Have to look and see which subsection that is, but that basically just describes if it's fenced, then it's posted. But then they added on in, I think 2009, another last line to that, right at the end of 207-200, subsection 5A. The term does not include a barrier made of barbed wire. So, it actually comes down to something as ridiculous as this fence has got woven wire on it, so I can write the ticket. That fence has barbed wire on it, so I can't. Well, you're talking about whether the land is used in agriculture, as I interpret it, just changes the interval that you need to paint the posts. The one being 1,000 feet versus 200 feet. So it's a little bit frustrating, like I said, when I get out there and nothing I can do about it, even though any reasonable person should have known that they were trespassing.
Commissioner Macbeth, did you have anything to add?
Yeah, so I just want to, I think you've clarified at least how you operate as a game warden. If a private landowner then calls up and makes a complaint, it isn't a matter of the game warden just because of the complaint writing a citation. They actually have to go out onto the landscape where the alleged violation occurred and investigate and gather facts and probably take pictures and, in other words, show, that the property was properly posted, and then go ahead and write the citation based on the facts. Because again, you're going to have to present your case to the district attorney and prove it. So I mean, you're going to have those facts, right?
Exactly. One instance I can think of in Washoe County, literally the guy leaned his 7 mag across a railroad type post that had a no trespassing sign on it, and there was an empty piece of brass at the bottom of it. That one's a no-brainer. That's a ticket for 503-240. One of the ones that I had last fall, the hunters were in a part of a hay meadow where you couldn't see any signs and everything, but I went back and looked at the gate that they drove in on, because the landowner had said that there was a sign on the gate that they drove in on. Unfortunately, the sign was gone, or fortunately, however, depending on which side you were standing on. But, had I been able to show that he drove through the gate next to a no trespassing sign, I would have written the ticket. But since he drove through the gate and there was no sign, I didn't. So, yeah, the burden of proof is on us to show that.
Okay, so and then clarify for me if all of the things were not done. So let's say there's a sign on the gate going in, goes down, but there's not the orange, and there's, the designated distances, and is there, how do you decide, based on the factual circumstances to go ahead and write that ticket?
Either if the hunter saw a sign, should have seen a sign, or it's properly marked, the 2,000 feet or 200 feet. If it's properly marked with orange paint or signs.
Okay, so it's or.
Exactly. It says, it talks about the square inches and the 12 inches at the top of the post and the intervals and all that sort of stuff dealing with orange paint. The other way to do it is just with signs where, you can see a sign.
Okay, so in the sign, there's no physical requirements as to distances or anything like that, but you, at that point, have to show that the person, had to have seen the sign as they went through a gate, or, when they shot their gun over the sign. Obviously, that one's pretty easy, but...
Right, and it basically just goes back to the term that was warned by the landowner. In the signs, you can talk about the spacing and the square inches and everything, but for the sign, if the hunter was warned by the landowner, in that case warned by a little square sign that said no trespassing, then they were warned, if that makes sense. And like I said, to repeat, we're okay enforcing the law at 3 demerits, and we're okay enforcing it at 12. Just wanted to clarify how we enforce it, so.
Commissioner Young and then Commissioner Drew.
Just a question, guys. My experience was, is there an exemption for trespassing and wildlife violations that the crime does not have to be committed in your presence? In other words, I was a police officer for 28 years in this state, and I always was taught that you can only make a misdemeanor arrest that occurs in your presence. So in Clark County, I probably arrested hundreds of people for trespassing in casinos when I was running the vice squad, most of them prostitutes. But the management there of the casino would have to have a representative of the owner there to either make a citizen's arrest, or I had to be personally present for the crime. What's different with what you guys, and in Clark County, we have to give the person afford them an opportunity to leave before an arrest or citation is issued. What's the difference in wildlife management, just for my own edification? If any of that makes sense to you.
No, it does. Yeah, it's still a misdemeanor, therefore it's got to be created in your presence. We've done them in the past. Even if we didn't even if we didn't actually see the person in the field, just based on our investigation of tire tracks, interviews, brass, that sort of stuff. There's a lot of things we do within the wildlife stuff that isn't in your presence. And
Does that require a warrant, or for the district attorney, somebody to issue an arrest warrant, or could you make an arrest or write a citation on just your own investigation, or would somebody have to review that?
I suppose Mr. Newton might have an opinion for us on that, but in the past we've done it without a warrant, just on our own investigation.
And I see why it's quite a bit different, and it would seem to me you should be afforded a little different latitude because it's a completely different type of situation in a rural area. Do the landowners, when they call in, do they ever make citizens arrests or attempt to, or are they ever instructed to, for trespassers on their property? Because they can make a citizen's arrest for that particular crime. It's a misdemeanor, and it is occurring in their presence.
I've often wondered that very thing, if it would be a little cleaner legally if they went and contacted the person. I've never seen any of them do it in my experience. Not to say it hasn't happened, but
Well, just to tell you, just to kind of give you, in the way it happens in the city, is the security officers in casinos make hundreds and hundreds of these arrests as a representative of the owner, or
And that's how they
any
detain
employee that's employed by the owner of the property has implied consent, is that they represent the owner of the property, and they can make that arrest. And it is cleaner that way because that's the way the law, to my knowledge, is written.
yeah.
For
And I
trespassing.
guess I have had landowners do it in which they didn't actually tell the person they were being placed under citizen's arrest, but they go up and confront the person, get a license plate, and say, yeah, it's that guy in the blue plaid shirt.
Tougher job in a lot of ways than people understand and realize.
Thank you.
Getting these, a conviction on.
Commissioner Drew?
Talk to me a little bit about non-navigable waters, and the reason I ask is I work for a company that does wetland delineations and defining navigable and non-navigable waters per U.S. Corps of Engineers. Makes us a lot of money and is also very difficult to do. So I don't think the state sees navigable waters and non-navigable waters the same way. I do know there's some gray area in relation to this, is my understanding. In fact, I was contacted by an assemblyman who had a bill in last session to try and clarify this a little bit. And I don't think anything actually got through, but the concern was there's a lot of gray area in terms of non-navigable waters that people could get caught up on. And so what's your thought on that? I know when I see it, it gives me some pause.
The research we did on navigable and non-navigable waters was based on definitions from Nevada state lands. And they say, upon statehood, Nevada received title to all sovereign lands which are submerged beneath navigable bodies of water. At the present time, the following bodies of water are considered to be navigable: Lake Tahoe, Washoe Lake, Walker Lake, Truckee River, Carson River, Colorado River, Virgin River. The state owns the beds and the banks of these bodies of water, generally up to the ordinary and permanent high water mark. It kind of goes on from there. So non-navigable would be all other waters. The point being, though, willful trespass upon a piece of property that was properly marked or signed for the purpose of hunting, fishing, or trapping. So, yes, the commission could make that determination that fishing would remain at a lower demerit point, but it's all a willful act to trespass upon that property for hunting, fishing, or trapping. That makes sense.
So a scenario that I've seen quite a bit is you have a river that likely falls under non-navigable, and it's got a fence that stretches all the way across it, and in the middle of a fence, there's a sign. Off limits completely, whether under the high water mark or not?
Non-navigable, yes, it would be off limits.
Okay, now we flip that navigable water.
You can be within a stream bed up to the high water mark.
If I clearly understand what the high water mark is.
Yeah, and it just talks about ordinary and permanent high water marks, so there is a little leeway there. So for instance, Truckee River, you could, as long as you access the Truckee River from a legal point, you can be up and down the length of the Truckee River. You can't walk across private property to get to the Truckee River, or you could get yourself in hot water. But once you're on the river from a legal access point, you can be up and down that river, no matter if the private property expands on both sides of it or to one side of it, public on one side, private on the other.
Commissioner Macbeth?
Okay, and Tonopah, we took a vote on this and approved the 12 demerit points, but I'm trying to remember, was that the department's recommendation to go from 6 to 12?
That was the trapping committee's recommendation.
Trapping committees to go from 6 to 12.
And I'm going to back up on that right there. We had, and I'll take 100% of the heat for this one. The only reason the demerit points are even discussed through the trapping committee was I got tired of having people come to the meeting telling me their horror stories, and we were only addressing time frames. And a lot of the horror stories weren't a time frame issue, it was people breaking the law issue. And we needed to address that issue. So I've been accused of going beyond the scope of what the legislation asked us to do, but that was a result of the trapping committee and the things I heard, and I said, okay, as a result of the trapping committee, things I heard, I want to get something going forward to fix these other problems that we became aware of through the trapping committee process. During that process, there were some acts that were occurring that were disturbing to me. Not only in trapping, but I was hearing stuff about hunting activities on private property, no fishing. And I had brought it up that I would like to have a two-stage. If you do something incidental, it's a 6 demerit, and have a two-stage that if it's with malice or whatever you want to call it, it goes to 12 demerits. The guy in a suit here told me that we couldn't have a two-stage thing because the way the trespass law is read in the state, it was either you do it or you don't. There is no, I would like to equate it to you either get a speeding ticket or a reckless driving ticket, depending on how fast you're going. He told us there's no speeding or reckless. It's all reckless because you did something willful under the way that 207-200 reads. It's a willful act to do that. So we didn't have the opportunity to leave a 6 for an incidental incident and take it to a 12 for something that I think is a 12 demerit type violation. But with the explanation that we got from the law enforcement today and everything, and on how far you have to go to get to that violation, I talked to one of the largest landowners in northern Nevada today and went over this with him, and he told me of incidents that have occurred on some of his property, that he had a hunter show up to his ranch, go in and ask his ranch manager, can I hunt on your property? He was told no. A couple days later, the same individual that was told no was contacted in the field by one of Endell's game wardens, and he had a buck in his camp, and he asked that individual, where did you take that buck? And the individual told him a location. The game warden had been watching this buck in his cultivated field, and he was a very distinct buck, and said, you didn't kill that buck there. Went and investigated it, found out where the guy shot from because they were in such a hurry to get that buck out of the cultivated field that they were told no, they couldn't hunt in. Found a shell casing, found where the deer was harvested, and from the point of the shot to where the deer was taken to the home, the occupied residence, they were in a dead straight line. To me, that's a 12 demerit point violation without a doubt. And some of the things we heard through the trapping committee with the pure disregard for private property rights, it rose way past a 6 demerit violation, and without a doubt was something that that person needed to pay a pretty good price for. Mr. Turnipseed brought up that a lot of the correspondence that we have all received in the past week, they must not understand 207-200. or a lot of the stuff that they were bringing forward as an argument against what we're trying to do here, it really doesn't apply. They're missing their mark, as I've seen a lot of times throughout two of these contentious issues, whether it's the bears or the trapping. I'm told that I don't listen to people and that everybody's against what I'm trying to do. I think the people that are spreading the message to get the people to go against us are the ones missing the mark. It's not me missing the mark of representing what I believe in. It's the people telling the people to write the emails to me that are misrepresenting what the message is and what is the consequence and what is the actual crime. I think if there's a misrepresentation to the people, it's not from this commission, it's from the people spreading misinformation to get people on their side, what side it is. So, you know, I would like to still have a 12 demerit point violation for trespass. If there was a way we could still keep a 6 in there, I'd like to. But from the stuff I've heard and seen throughout this process, there's some individuals doing some very bad things. And the landowner that I spoke to today said that he had an antelope harvested in one of his fields, and there was a game warden there was a ranch manager there, and they went and investigated it, and the landowner went up and looked at the situation and said, you know, I don't think I have that properly marked, don't prosecute him. And NDOW gave him a warning at that time. When NDOW law enforcement thought, you know, this is close enough, I think we could pursue this, it was a landowner that went up and looked at his own situation and said, you know what, I don't have enough to bring something forward here, so let's give him a warning this time, and I'm going to better mark it so it doesn't happen again. So that's where I'm at on this whole thing. I probably went on longer than I needed to, but that was my thought. Commissioner McBeth.
Okay, so for the record, looking at the entire list of demerit points, some of the 12 points at issue are unlawfully shooting of a big game animal or game bird from an aircraft, spotting or locating mammals or game birds from an aircraft, unlawfully using a helicopter to transport game, hunters, or equipment, unlawfully killing or attempting to kill birds or animals from an aircraft, a lot of aircraft stuff, unlawfully using an aircraft, balloon, or satellite to locate or observe big game for the purpose of hunting, hunting or taking an endangered species without a special permit, unlawfully killing, destroying, wounding, trapping, or injuring bald eagles or golden eagles, unlawfully taking bald eagles or golden eagles, taking twice the legal limit of more or more of a big game mammal, unlawfully possessing live wildlife that is classified as prohibited, unlawfully possessing big game mammals during the closed season, unlawfully importing or transporting a prohibited species of wildlife without a permit or license, collecting unprotected wildlife for commercial purposes without a permit, collecting live bait fish or live aquatic bait for commercial purposes without a permit, collecting unprotected fish for commercial purposes without a permit, obstructing, hindering, or otherwise interfering with an officer, employee, or agent of the department, unlawfully selling big game mammals, unlawfully selling endangered species, needless waste of big game mammals. Conviction of a felony for intentionally killing a big game mammal, including aiding or abetting a person in the commission of the killing. Conviction of a gross misdemeanor for intentionally killing a big game mammal, including aiding or abetting a person in killing the commission of the killing. Conviction of a gross misdemeanor for willfully possessing an unlawfully killed big game mammal. Acting as a master guide or sub-guide without a license. Furnishing false information to obtain a big game tag. Refusing to exhibit a licensed wildlife, weapon, ammunition, device, or apparatus. That's it. So obviously it's in a class of pretty bad conduct by the person who is cited. And so I guess where we have to come in is, you know, in the context of this particular violation and the other 12-point violations we have, do we think that this rises to that level? And I think that's what we got to decide.
Commissioner Drew.
Yeah, and just to clarify something, you'd mentioned we approved this in Tonopah. I think what we did is we adopted the committee recommendation and asked the department to draft regulations. So nothing has formally been approved. That's, I think, probably that discussion will happen tomorrow. But along your second point in terms of, the egregiousness of this, and maybe it's just that I am not comfortable with the NRS, and maybe even without that. I mean, some of the things Jack mentioned, egregious. Are there possibilities that someone could be unknowingly get hammered on this thing? Is there a possibility that NRS 207-200 could change? Yeah, I mean, we're talking about revocation of license for 3 to 5 years, which is pretty significant, especially for folks entering the hunting and fishing field who may not necessarily completely understand this. And I say that having been a mentor to a lot of first-year sportsmen, regardless of age, that simply may not understand all this stuff. And 12, I don't see it. 9, maybe. But I just think this is a knee-jerk reaction that's a little too severe for me to be comfortable with.
And I'm going to let Mr. McBeth go and then Mr. McNinch, but I'm going to say I agree with you with your mentoring and different things, and that's why I wanted that 2-stage, because I do believe there's 2 different acts. I just don't know how to get there, because without a doubt, in my mind, there are some acts that constitute a person losing their license. No doubt in my mind. But there are, every one of us in this room was 16, 18 years old at one time. So there's the other side of the coin. So I wish we could have the 2-stage thing. That's what I'd really like to get to, but minus that, I do agree with Commissioner Drew that, there are some circumstances that a young person could pay a hefty toll. And I have to keep that in mind, but I also keep in mind that people do some very bad things that 9 demerits doesn't get to the act that they committed, without a doubt. Commissioner McBeth, and then we'll go to Commissioner McNinch.
Okay, and I just want to put this all in context for those of you that were not in Tonopah. We had another very long meeting, and we literally considered this at the very end of the meeting. And I can guarantee you, I don't know how everybody else felt, but it was, I wanted to get through this. And so, by, accepting the recommendation of the committee, I'm glad we did, because it sparked a lot of debate, and we've got a lot of discussion, I'm sure, that's going to come about from it. And so I'm not sorry we did that, but, it's allowed me to, look at this a little bit closer now, and I'm sure we're going to hear some more testimony. And so, anyway, I do personally think that it's an egregious act. But I am seeing that there are some, situations where, is losing your license, necessarily the, for that one violation, the answer. So, anyway, thanks.
I have one question for you, Mr. Turnipseed, because you've got a lot of field experience, and you mentioned you had 8 of these instances last year. I'm sure you recognize the difference of what I'm saying. You've got a kid that's excited, that's never killed a deer, doesn't understand all the laws, makes a mistake. Is it up to the homeowner to say he didn't have permission, or the landowner? I mean, people have stuff posted all the time, but they can give permission to certain individuals to be in there. Does that put a property owner in a bad position to say, hey, John Smith, do you really want to hammer this kid that 13 years old shot a buck? But in the same sense, if it was a guy my age that couldn't pass up a 200-inch buck in his field, those are 2 different situations. Do you see How would you approach that as a warden? Is it part of the property owner's discretion also?
Yeah, it puts, you could even take it a step further, not just a kid with a deer, but a difference of a 50-year-old guy shooting a 200-inch buck across the railroad tie with a sign on it versus, a guy wading up the Humboldt fishing for catfish and goes under a sign. Or, a guy that sails a duck for 100 yards and so he runs out and picks it up. It would all fall under this. So you're right. We could use some discretion in how we're going to enforce that, and the landowner could use some discretion in saying, well, yeah, okay, I understand this time. But as far as officially in black and white, it's all the same. 207-200 and 503-240. Neither one of those two statutes care whether it was a 200-inch buck or a catfish. So yeah, it puts us in a little bit of a pickle as to, we try not to be out there making decisions as to when we're going to enforce the law and when we're not. Obviously, we have discretion. We do that every day, but yeah, we try to avoid those pickles, I guess. Does that make sense?
Commissioner Bliss?
I just like that. I spoke with several private landowners that I know that own quite a bit of property and have hunting issues every year. I run this scenario by them, and every one of them said, the person that makes an honest mistake, excited, heat of the moment type of a deal, if we confront them, they are apologetic. They know they made a mistake. They feel bad. He said you can see those people when they're like that, is one thing. But they've also had people shoot deer in their field and have basically told them to go to hell, that you don't own this deer. And so there, just like Jack has said, there is two different levels of this. They all said the guy make the honest mistake, the kid, no, we don't want to have that on our shoulders, that we pursued it, and that kid or that guy that made somewhat of an honest mistake, if he doesn't know that the 12 inches on top of the post that's orange, it means private property. If he honestly didn't know that, they didn't want the responsibility of that person losing their hunting privileges for 3 to 5 years, not just in Nevada, but surrounding states. But they also felt strong that the guy that was ignorant about it, they felt that that guy should get hammered. And they wouldn't feel bad about him losing his license, other than they said if they were that ignorant, they might have to worry about their haystack burning up 5 years down the road, So,
as Chairman Robb said, it would be nice if we could have a graduated scale of the one being the kid with the catfish and the other being the 200-inch buck, but it sounds like that conversation occurred in Tonopah, and that's not an option.
You're the guy in the suit. Do you see any way to get to where we would like to? You understand the discussion, and I think every commissioner up here realizes that there's two circumstances that occur here. One that's not as bad and one that goes beyond. Do you see any wiggle room to do anything different any other way?
I do, but I think it would be a legislative change that you would have to go through because of the way things are drafted currently and the restrictive language in 207-200. I think you'd have to get a new statute created for your own trespass purposes that broke it up, one dealing with 207-200 and its dictates, and then one being a lesser offense type category.
If you looked at, say, 80 miles an hour, so you're in 55, an officer has discretion between speeding and reckless driving. Is that an NRS or an NAC that gives that officer that discretion, the difference between speeding and reckless? That's why I'm trying to come up with something so we can have something on that equivalent in that par.
That discretion is based on the officer and how he classifies the violation. It's not an NRS or an NAC that does that. It's simply the officer saying, and you can see it on the tickets, it will say clocked at 92, but cited for 10 over. That's the officer making that determination based off what he's seen in the field.
But how did they get there through traffic violations? I want to get there through wildlife violations, get to that same thing. Is it NRS that gave them that ability to get there, or is there an NAC someplace that we could find that could give us that same leeway? And even if the officer writes it for a reckless driving, the guy can take it to court, and the judge could reduce it from reckless down to just speeding at a judge's discretion beyond what the officer wrote him for. And that's I think what we're trying to get to here. It's just how do they do that through the higher patrol, and how can we apply that to NDOW and wildlife enforcement?
As I said a moment ago, I think you're going to have to do some sort of legislative change to get that because of the reference to 207-200 and how it outlines that violation. You're going to need something that allows you to find a violation that does not involve 207-200.
That's what I'm saying. I'm trying to go backwards into this. 207-200 is very specific in its language. Can we come up with, and it says, 207-200 references everything, our current trespass, 6 Demerit 1 references that. Is there any way we can come up with a law that is lesser for an incidental trespass like we're trying to say, and not reference 207-200? Use 207-200 to get to the 12 Demerit 1 and come up with a way that we don't reference 207-200 and have a lighter infraction by using this one going up and creating a new one that's lesser. Did I confuse you?
No. Maybe, I guess my answer hasn't been clear. Your statute that talks about it being unlawful to hunt on private property refers specifically to 207-200 as what outlines private property. What you're looking for is something that goes along those same roads but isn't as restrictive, that recognizes a non-willful trespass. You don't have that in your toolbox yet. So you're going to need an amendment to 503-240 that differentiates a trespass that is under 207-200, thereby being willful, and a trespass that is not under 207-200. And the only way to do that, because it's in a statute, is through another statute or amending this statute that I can see. Even if you drafted something, I think LCB would reject it because of what's in 503-240. That's my concern. If you go down that road in a regulation standpoint, they're going to say that regulation conflicts with statute, which they can't do.
Commissioner McMath.
Dag Newton, will you get 207-200 in front of you? You got it in front of you?
I do.
In subsection 2, it talks about the sufficient ways of warning against trespassing. That's the way it reads. It says a sufficient warning against trespassing within the meaning of this section is given by any of the following methods, and it goes through the methods we've been talking about.
Correct.
But when you go up to 1B, it says willfully goes or remains upon any land or in any building after having been warned by the owner or occupant thereof not to trespass. Is subsection 2 on the methods of warning of a trespass different than a willful trespass that is what is addressed in 1B? In other words, if you have a 18-year-old hunter who goes out and there is a posted, a fence that has the orange marks and no signs, and he shoots, let's say, a deer in a field, it's obvious a trespass, and the warnings are there, but if the state can't prove willfulness, which is an intentional, in other words, when we go to criminal law in law school, and I'm not a criminal attorney and everything, but I'll tell you, you had to have criminal intent, and that's what the word willful really gets to.
The way I read this statute is Section 2 outlines what defines a willful act. Because it says willfully goes on after having been warned not to trespass. And then Section 2 defines how you warn someone not to trespass. So if you've issued the proper warning.
But does it warn against willful trespass? That's the question.
If you've
You're
issued
interpreting to say that if the orange markers are up, then that's willful. If the mere trespass occurs with the orange signs, then that's willful.
That's how I'm interpreting the statute, yes.
And there could be a citation issued. Now, this is barring discretion of the game warden. Game warden could make the discretionary decision not to cite because of the age being a mitigating factor, and possibly even the landowner would as well agree. But the fact of the matter remains that if the landowner is hard and presses NDOW to cite, and NDOW cites, then we can have a situation where an 18-year-old has a willful trespass under this provision and could be cited and would have the resulting demerit points. And the commission wouldn't be able to do anything on that because from a procedural standpoint, all they'd have to show is the violation. Now, the young fellow could go to court and try to, get it pled down and go through the process, to try to, lessen that citation. But if he ultimately either pleads guilty and accepts the citation, or a judge finds him in violation of this, then at that point our hands are tied. If the proposal is 12 demerit points, then that fact situation we'd end up with a young 18-year-old who loses his license, right?
That's the way I'm interpreting the statute, yes.
Commissioner Drew?
I guess that summarizes my discomfort with this thing from the beginning. I get where Jack's going, but we're managing for the extreme, what I view as the extreme case, and potentially catching a lot of the gray that falls between black and white. I mean, to use a speeding analogy, if we want to do that, since you understand those well. Yeah. We're going from 0 to 120, and we passed everything in between, especially for fishing. We went from this being a 3 demerit to a 12 demerit. I mean, that's a big jump. And you go from, the potential to work down your demerits to not having that, to having your license revoked and suspended not only in Nevada but all western states. I mean, this is a significant jump for me on an issue where there's a lot of gray area. It's not always black and white to me.
Commissioner Bliss?
I think Commissioner Drew just kind of answered my question indirectly, but I was going to ask, if a 6 or a 9 demerit point, you can do your hunter safety class and reduce your demerits down one time in 60 months, if I understand like what you said.
9 demerits.
To down 4 demerits.
Once you hit 9, you can take it.
Once you hit 9. Okay, but you cannot do that if you get an automatic 12.
That's correct. The statute specifically states that it's up to 9. If you get a 12 all at once, you don't have that ability.
Yeah.
Okay.
12 is done.
Okay.
And I'm not disagreeing with what Commissioner Drew said at all. And I have concerns about the 18-year-old kid or, somebody makes an honest mistake. That stuff happens. But I do have concerns about there's some bad apples that need to get taken out, and they're not. And the way we've always done it is we err towards protecting the most people. I'd like to see us somewhere find out how we can get to a 12. Maybe talk to a legislator and say, hey, these are issues we're seeing. Is there something we can do? But we all know you open up 207-200, we could come back with something that doesn't work. You open laws and it's a crapshoot. You got an idea to open a law and it changes so much you went backwards. So even though I want a 12, I don't think we're going to get there. Commissioner McNinch.
So what's been rolling around in my head a little bit is, if we decide to move forward, I understand the 12, and it's a tough one, there's no doubt. What if we were handling it the way that we're proposing to handle some of these others? Here we have a 3-point demerit as it sits now, where pretty much you can do what you want and take a class every 5 years, and you're probably never going to hit 12 and be worked out of the system for consistently violating, walking onto somebody's personal property and getting caught. I mean, we know how many times, but what if that was changed to a 6? They'd get a couple shots at it every 5 years, and if they get caught, then they'll get worked out of the system. I mean, we're talking about an education issue here, and that first go around, there'll be some education to it for sure. That it'll create an awareness, and people will take some responsibility for asking the question. Am I going to go onto somebody's property or not?
Any other commissioners? We got some public comment we got to get to also. Anybody else have anything? Thank you, too. And we'll go to public comment. Mr. Turnipseed.
The other one?
For the record, Mike Turnipseed, representing the Douglas Cab. Go back and clear up navigable waters, and I believe Paul recited the ones that are in statute, I think in 533, 540. There's one other one, the Dankowski case declared the Carson River navigable. Okay. It seems like the hysteria over trapping has spilled over into hunting and fishing. What I'm hearing is that maybe no change is better than changing from 12 demerits if I'm fishing on property. This has happened to me.